State of Michigan versus Raymond Kiyomi. Jima, is it? Kyogama, 25-03499, appearance, please.
Thank you, Your Honor. May I please support Assistant Prosecutor Attorney Dan Smith appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. Ronald Berry appearing on behalf of Mr. Kiyomoga, who is standing to my right at this council.
Okay, they was set for a preliminary examination for malicious destruction of property, 20,000 or more, larceny, 20,000 or more. My understanding is that we're not prepared to proceed.
No, Your Honor, the people are going to request that this matter be adjourned and set. The defendant has a co-defendant case that was set for next week. That co-defendant is Sierra Dryden. In order to.
Why are you coming to my courtroom having a whole conversation, Mr. Nib? Why are you opening our door, having a whole conversation while we're on the record?
Also want to talk.
We are on the record.
I'm sorry.
Thank you.
In order for judicial economy, we ask that these matters be set together. I attempted to, or we need to coordinate with the defense attorney about what's the best next.
So there's a co-defendant on this.
Yes.
It's for this week for exam.
It was, but it's May 1st.
May 1st is the next one, the exam.
It's in the morning, I presume.
9:30.
9:30. Okay. Based on the co-defendant, I will find good cause to reset this in the interest of judicial economy. I'm trying to see where it is. Okay, Sierra Dryden.
Yes, Sierra Dryden.
So we'll research to that date and time. Any additional matters?
Nothing from the people, Your Honor.
Nothing, Your Honor.
No, thank you.
Continue as always, Judge.
Where's he housed? Where's he living?
Oh. Your Honor, my understanding is he's living at the Pinnacle Recovery Center.
Okay, treatment facility.
Yes, Your Honor.
Got it. Okay, sounds good. Thank you.
Thank you, Your Honor.
Have you seen Mr. Edwards?
We'll just call that the Williams Food Project.
Yes, sir. George coming in here. George coming in here like we, I know, like we chilling. This ain't the store. This ain't the store. David Brown's not here.
No, I called home. There's nobody
He
here.
doesn't have an attorney.
No, he's supposed to be retained.
Circuit court to represent, okay, why are we going to do this? Just let them know. They can set that for a court date if he has an attorney. Okay, give me my daughter. Let's see, State of Michigan versus Elijah Williams, 26-00510, appearance, please.
Thank you, Your Honor. May I please support Dan Smith appearing on behalf of the people.
Thank you, George and the APD on behalf of my client saying to my right.
Okay, and Ms. Williams is here for a prelim on police officer assault versus obstruct. Are we prepared to run our exam?
The people has the necessary officer here, and we are prepared to move forward.
Eric, I was going to ask the court for a 5-minute recess. I talked with my client yesterday and today. I had maybe a competency issue that kind of alerted me.
Competency.
Potential. I want to speak to her mother for about a few minutes and then we'll go from there. I just found out about some hospitalization. I did not previously know about until this morning.
Sounds good. And we have not seen David Brown. He does not have an attorney. I'm gonna issue a page more. Well, I guess I'll give him a couple more minutes. It is 9:05. Is Jeffrey McKenzie here?
Yes, Jeff.
Okay, what about his attorney?
Goodrich was here. He stepped out.
Okay. I'll look.
As soon as you let me know.
Oh, no worries.
Let me know, I can talk to them about the rest of it.
It is 9:30, yeah. But I'll come sign you.
Okay.
David Brown. Oh,
Any micro rates?
Mr. Brown, do you have an attorney? You come forward. A State of Michigan versus David Brown, 26-00261. Appearance for the record.
Thank you, Your Honor. May it please the court. Dan Smith, appearing on behalf of the people of the state of Michigan.
Okay, and Mr. Brown is present in court, and you were making efforts to retain Eric Shepherd.
Yes, ma'am.
You're still doing that?
Yes, ma'am.
Okay, and how far along are you in that process?
I was close to about two payments away. I just got paid this morning. It was unfortunate that he couldn't make it.
You said you're about 2 payments away, you said?
Yes,
Okay,
yep. So the month of February got kind of rocky. I had just got out and stuff like that, coming off the layoff. So it's like the weather started acting funny. So it was kind of weird. A lot of up and down days. So my average hours about 20 hours a week.
so you intend to make a payment today is what you're saying?
Yes, ma'am.
And then you're gonna pay the rest when?
Next 2 weeks, I should have everything.
Okay, we're gonna reset this after that. He's already waived the timeline.
And I just want to note that the necessary officers are here and the complaining witnesses also in here. We would have otherwise been prepared to move forward this morning.
Thank you. There's a soft, assault. May 1st at 8:30. Do you have any questions today, Mr. Brown?
No, Your Honor.
There's still a no contact order that will continue, and all your other bond conditions. We'll see you on May 1st.
Mr. Brown. He's gonna get right now. Your Honor, am I okay to release my officer for this case?
Absolutely. Jeffrey McKenzie was here, but Mr. Goodrich.
Yank them on the hallway, talk to them.
What about Edward Nicholson and Mr. Lee, or Brandon or Price and Miss Donnelly?
Simmons down here. We have not
Okay.
seen
On the record in the matter of the state of Michigan versus Jeffrey McKenzie, 25-02814. Appearance, please.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. McKenzie, who is standing to my right.
Okay, Mr. McKenzie was scheduled today for sentencing, and I do have a pre-sentence report and a recommendation that was prepared on the 23rd of March. And counsel, you did get a copy of that.
I did, Your Honor.
I think we need to make corrections. I think.
The only kind of sort of correction we have is under employment. He has been hired by a company to work on pools, but he hasn't actually started yet.
What company is that? American Pools. That's the only update.
That's the only update we have.
Make your allocution.
Thank you, Your Honor. Your Honor, this situation arose when Mr. McKenzie was trying to help a friend out in a situation with her breakup with a boyfriend. He understands he made a mistake and handled things poorly by moving the guy's vehicle around the block to try to get him out of the house. He's taken responsibility for that. I think he certainly admitted that to the probation officer. I don't think this is a person who has a ton of needs that need to be addressed by probation. I'm glad to hear that he has recently gotten employment with working on pools for where money's coming here. We would ask the court to consider a fines and cost sentence. However, if the court would like to place him on probation, he's certainly willing to do whatever the court asks, Your Honor.
He's got 3 days, Ingham County Jail. I'll credit him 3 days. He's all set.
Okay, all right, thank you, Your Honor.
Okay, that was that one. Did we see Ms. Donnelly or Mr. Lee?
I'm seeing her.
Lee is in Buchanan right now.
Or competency? Was he supposed to- Yeah, this is. Oh, they provided a letterhead. Yeah.
Did they,
That.
did they provide?
Would you like to see?
Yeah. Did they provide additional opinion about?
No, they just typed
They
some,
did
they
add
just
a
typed some
line.
letterhead.
Okay.
The last one, they added a line.
Yeah, the last one had that.
But
Okay.
I did push for your letterhead, Abby. I got it.
It's the best I can do.
I'm like, can we just check what clinic, like what else? I don't know.
I just don't understand. Is your client here?
Your Honor, I have not been able to reach Mr. Orprice.
Oh, that's unfortunate. I was hoping that you would be here so we can resolve this.
Me too.
Okay, well, and you have not had contact, obviously.
No, I didn't see anyone. I didn't see him in the hallway.
Got it. Oh, it's your big one. Did report for the interview, I don't know.
He
why
did.
didn't. Okay.
It was just, I think I'm just checking my notes. I think I called him and it went straight to a voicemail that was not set up, so I didn't email him.
Okay. Sure, make sure, you let me know if you hear back from him.
All right, thank you, Your Honor.
Thank you. The jail didn't bring nobody in, and the rest of our, it's pretty much jail.
Yeah, how long did they extend?
I asked if they didn't know, but they're on the list.
Mr. Lee,
Oh, the jail's not.
the jail's not here yet.
Well, there's one load here, Your Honor, but there was four.
Oh, there's four loads. Four
Well, no,
people.
there's four defendants and one trustee that hasn't made it yet. There was a load that came earlier.
Are all the four defendants mine?
Right.
I don't know, Your Honor, but one of them is because he's my client's Hawkins.
Oh, okay, sounds good. Ms. Donnelly has Mr. Anderson too. I don't know what she's doing with that. You're waiting for Hawkins? Is that who you're waiting for?
Yes, Your Honor.
Okay, he's not here yet. I've not seen Mr. Sarks,
He just poked his head in.
but he has Johnston at 10:30, but he's got time. Anderson's supposed to be here for Donnelly. And then Mr. Lee, we did, I guess, get something from yours, so let me call that case. This is the state of Michigan versus Eric Nicholson. This is in file number 25-02278. Appearance, please.
Thank you, Your Honor. May I please report, Assistant Prosecutor Dan Smith appearing on behalf of people.
Assistant Public Defender John Lewis, appearing on behalf of Edward Nicholson.
Okay, I think we reset this matter so that we could get the independent evaluation reports submitted in a form that presented more professional from a medical evaluator. We at the court received, it looks like one page where there was a typed name of the doctor.
You didn't receive the rest of the report, Your Honor?
Well, I don't believe so. Nonetheless, I don't think it's changed. I don't think the report has changed anyways. And so I know that the prosecutor had objected. Does this satisfy the prosecutor?
People are satisfied.
So the court will adopt the report and incorporate it into the findings of the file. And where is your client?
Your Honor, he apparently is not here, but I have been in communication with his guardian. We'll make sure.
No, I'm just wondering, is he in a treatment facility or he's not?
Oh, he is. He's in.
Okay. Okay, it's gonna say he's gonna be ordered to undergo treatment. And we'll see if he can regain competency within the statutory time frame. Any additional matters for the record?
Nothing from the people, Your Honor.
I don't know, we might have to change the date.
Thank you. Your
Thank
Honor.
you.
They got our people.
Yes, even downstairs.
I'll find it. for you.
Yes, you know.
It's, that sounds very familiar to me, but.
That's the prosecutor.
Oh, okay.
One second. Yeah, sorry. One second. What was his first name?
Oh.
Have we seen Ms. Johnson? We need Ms. Johnson, we need Ms. Donnelly, we need Mr. Raleigh. There's Ms. Donnelly, she's walking fast. Warm chicken. Are you sure you want your jacket in here? It's a little warm. No.
So, they were supposed to use did you have to travel? Do you want?
No, I'm sure. I'm good.
Okay, sure. Oh, yes. I get paid.
Okay. All right, thank you for coming. I'm
Thank
sorry
you.
we didn't.
Yeah.
update you about that.
All right.
It says defendant's motion to withdraw this set for me on March 23rd at 10 a.m. That's when the pretrial. Said because I think the judge didn't even put him on one time, and we had a jury trial that day. Again, Ms. Johnson talked to me. Yeah, but this says the defendant's motion to withdraw was set for that. No one, no one. A pretrial might have been, but we didn't even receive this until after the 24th. Yeah. Yeah, because they can't do an ex parte. I can't just sign them and they have to send it for a hearing. So. All of these have to have a hearing or give them an opportunity, really a sufficient time for the other party to respond. So that's why we said it for hearing, because the defendant might show up. Oh, he's in custody. How she was trying. Because I think she said that day that he. No, she put that on all of us. It was all the same defendant? Yeah. Oh, okay, yeah, she can set it for a hearing. So Etheridge's client's not here still?
Yeah.
Yeah, yours.
They said they're here now.
Yeah, I'm just verifying this last one.
I gotta go back down there.
I saw Miss Donnelly walking fast. Is she ready with Anderson? Anderson's supposed to be in custody. Ritz is supposed to be in custody with that's Raleigh's client.
We got all of them just verifying, the last one verifying is Mr. Johnson, Mr. Johnson.
Okay. But really, we're just waiting for Raleigh because he was at 9. Yeah, he was at 9. Everybody else at 9:30. Oh, I think maybe hang on here. People gotta get their nails done. Ritz.
Yes.
Yes.
Okay, on the record in the matter of the state of Michigan versus Michael Ritz in 25-03672, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Jacob Riley appearing on behalf of Mr. Ritz, who is present to my right.
Okay, Mr. Ritz is scheduled today for a preliminary examination for larceny in the building and stolen property. There's an offer for him to plead guilty to an amended count 2, receiving, or to plead guilty to count 2, receiving, considering stolen property, $200 or more, but less than 1,000, and dismiss count 1, which is larceny in a building, and pay restitution to George Champion. The amount of restitution is $1,230. No objection to his release from jail for treatment. He's not in jail. He's in Gratiot County, correct?
That's right.
So that's a complete and accurate understanding of the plea offer.
Yes, Your Honor.
Yes, the people who made that offer, that's accurate.
Okay, you want to accept that offer, sir?
Yes.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
You can put your hand down. Okay, I have an advice of rights and plea information sheet. It has today's date on it. That's your signature.
Yes.
You went over these rights with your attorney?
Yes.
You understand those rights?
Yes.
So you're presumed innocent until proven guilty. You understand that? You have the right to maintain your innocence and take this matter to jury trial and require that the prosecution prove each element of each of the charges beyond a reasonable doubt before you're considered to be guilty. You have the right to see, hear, or question any witness called to testify against you, the right to call your own witnesses to testify on your behalf, and the right to present evidence that you believe show a defense to this charge, and the right to remain silent and not have silence be used against you. You understand that?
Yes.
You're willing to waive those rights today?
Yes.
Anyone threatening you to get you to waive those rights? Any promises extended to you to get you to want to waive these rights? And you are in custody for what? Okay, so you're not on probation or on parole. You understand that a guilty plea can result in a conviction that you may have to report to a current or future employer.
Yes.
It also could have impact on where you can travel or get immigration status. You understand that? So you may want to go on vacation in the country, they could deny you because of this conviction. You understand that?
Yes.
As to count 2 stolen property, receiving, concealing 200 or more, but less than 1,000, how do you plead? Is that because you believe you're guilty?
Yes.
Factual basis.
Mr. Ritz, are you aware of a home located at 2345 Lyons Avenue?
Yes.
That in the city of Lansing, Union County, state of Michigan?
Yes.
And are you aware that some items were taken from that home on or about September 30th of 2025?
Yes.
And is it true that at one point you possessed or took part in possessing some of those stolen items?
Yes.
And you're aware that they were taken without the owner's permission?
Yes.
And were you aware, did you become aware of that while you possessed or took part in possessing those items? And would you agree that the approximate value of those items would be more than 200 but less than $1,000?
Yes.
I believe that's a factual basis.
Any questions from the prosecution?
No, people are satisfied.
The court is satisfied with the factual basis. I'll accept your plea. If I your plea to be freely, voluntarily, and intelligently made. And there's obviously no objection to restitution in an amount of $1,230.
Yes, ma'am.
How long is he in custody for?
I know he has been in custody since December in Gratiot, and he is due to be released on May 26th.
Yeah.
May 26th to enter into substance treatment. That's why we asked for that provision of the prosecution not object to release for that purpose. Depending on what the court sentences.
As a witness here or victim?
Yes, the victim, Mr. George Champion, is here and he's present. Did you want to say anything? He does not want to make a statement.
You can make allocation.
My client certainly made a lot of poor choices in the last year. A lot of them are related to substance abuse issues that he had been going through. It landed him with a pretty serious case and sentence in Gratiot County that he's still serving. I think everyone there understands that he needs to address his substance issue. That's where they're going to be releasing him early on May 26th to enter into inpatient treatment. Our request is that whatever court or whatever sentence this court imposes, that he'd be allowed to enter into that treatment when that time comes. I think I should also note he is going to be on probation with Gratiot County for I think 2 years following this release.
Does your client want to make a statement? The sentence is 180 days in Eagan County Jail. I will allow you to be released into the custody of inpatient treatment only. If you're not successful at inpatient treatment, you will serve the balance of the 180 days. Do you understand that? Okay. I'm also going to order that you pay $1,230 in restitution, $75 for crime victim rights, and $50 state minimum costs. I'll waive discretionary fines. You'll set up a payment arrangement once you're out of treatment. Do you understand that? What's your permanent address?
5 Giles Street, St. John's, Michigan.
505 Giles.
Yeah.
That's Giles.
Yep.
St. John's. Phone number.
I don't know.
Okay. Any additional matters for the record today, council?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set. Thank you. Mr. Austin is here. Is your client here? I haven't seen Miss Donnelly.
I'm sorry, Your Honor.
I was talking to her. Mr. Etheridge, do you want your client brought up at all?
Yes, Your Honor, do a waiver.
Okay, you can bring up Hawkins. Mr. Austin, what are we doing with Stroud?
Your Honor, Ms. Lott and I would like to have a conference with the court first before we can proceed.
Ms. Lawton, is she here?
Yes, she was just here. She just stepped out to see if she had some additional witnesses here.
Okay, and then
I would like to refer my client to competency, Your Honor.
let's see, on the record, in the matter of the state of Michigan versus Elijah Williams, appearance again.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Dan Smith appearing on behalf of people.
Yes, Your Honor. Thank you. George Annette, APD on behalf of my client, St. Clair.
Okay, you've spoken with your client and you believe that there's reason to have her undergo a competency evaluation?
Yes, Your Honor.
Okay, you completed paperwork at all? Or?
No, I will fill that out. And
Okay.
send it to you.
Any objection from the people?
No objection, Your Honor.
Just, yeah, thank you.
Okay, so the court will find the cause to go beyond the timeline so that you can undergo a competency evaluation at the Center for Forensic Psychiatry. Your address is on Hope Road? Okay. And so it's not gonna be an issue getting in contact with her
No.
for the purposes of getting the
And her mother.
evaluation done.
Yes, you're correct, Your Honor, no issue.
Okay, and her mom is here. Is that
Yes.
correct? Bond will continue and she'll gonna be in contact with forensic once they get the paperwork. Any additional matters for the record?
No, I just want to note that the officer was here, present here today. We were prepared to move forward. Other than that, nothing from the people you're on.
Thank you.
We'll take for us to release Kurtz.
Absolutely. Let's see. I've not seen Ms. Lawton yet.
She's right here, Your Honor.
Oh, got it. Need to counsel or consult in the office or?
If we could,
Okay. This is State of Michigan versus Timothy Hawkins, 26-00506. Appearance, please.
Thank you, Your Honor. May I please report Assistant Prosecutor Attorney Dan Smith appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Derek Etheridge on behalf of Mr. Hawkins, who is in the courtroom standing to my right.
Mr. Hawkins is being charged with a criminal sexual crime third degree, the sex offender failure to comply. My understanding is that there's an unconditional waiver being offered today.
Yes, that is my understanding, Your Honor.
Yes, that's correct, Your Honor.
Okay, is there an offer at this time?
There is no offer.
And the people are waiving.
People will unconditionally waive, yes.
Okay, and Mr. Hawkins, you understand your right to have a preliminary examination here on the felony charges?
Yes.
You understand the purpose of the preliminary examination?
Yes.
So you have the right to have the prosecutor establish that they have sufficient probable cause that a felony was committed, and then probable cause sufficient to charge you as the person who committed the felony. You understand that?
Yes.
You wish to unconditionally waive your exam?
Yes.
Anyone promising you anything to do that? No. Your bind over date is April 8th. That's the date the circuit court receives the file from the district court, not the date that you need to appear in court, okay? Your next court date will be set after that. Your attorney will be made aware. Do you have any questions? Bond was set at 20,000 cash surety. That will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Thank you. Okay, let's see. Did we see Ms. Donnelly?
I didn't see it on the record.
Okay. You didn't see Mr. Sertz either. Ms. Donnelly had a 9:30 with Anderson. Are we expecting to run that? Do we know?
Can you repeat that?
Anderson, Mark Anderson?
He's here.
The officer's here?
We haven't spoken to Ms. Donnelly about.
Yeah, I saw her running around. I don't know where she is. So
I will go look for Ms. Donnelly.
she might be over there, because I just wanted to have him bring up the next person if possible.
So I already talked to your wife and I'm going to be a social worker. With contact with her and you, okay? Try to work on that. Well, sorry.
She's having- Are you ready? She's got it.
I'm gonna say from
Okay. Oh, he's saying radio if you need him. Okay. Okay, State of Michigan versus April Straw, 26-00661.
Morning, Your Honor, Jennifer Lawton on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Ms. Straub. She stands present to my right.
Okay, Ms. Straub was scheduled today for preliminary examination. And my understanding is there is going to be a plea offer today.
Yes, may I approach, Your Honor?
Yes. Thank you. Okay, so I have here that the offer is for the defendant to plead guilty to disturbing the peace with a term of probation and no alcohol while on probation. Is that correct?
That is correct, Your Honor. People would dismiss the balance of the charges.
That's my understanding as well. It's what I've conveyed to Ms. Straub. It's been properly memorialized in the plea sheet that I have reviewed and gone over orally with Ms. Straub as well.
Thank you, Ms. Straub. You want to accept that offer today? Yes, ma'am. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Maybe put your hand down. Okay, you have the right in this matter to proceed to trial on the original charges and the right to the presumption of innocence until proven guilty. Do you want to waive that right today? Okay, and so this is an advice of rights. This is your signature? Okay, so with waiving your right to the presumption of innocence, you're also gonna give up your right to have a trial. You have the right to jury trial. You have the right to remain silent at trial and not have it used against you, the right to see, hear, or question any witness called to testify against you at the trial, the right to subpoena witnesses to testify on your behalf. You can also waive your silence and testify at your own trial if you like. You understand that? You're willing to give up all of those rights? Anyone threatening you to get you to do that? Any promises extended to you to get you to plead guilty to the amended charge? You're not on probation or parole, correct? You understand that a guilty plea could result in a conviction that you may need to report to an employer or put on a future job application. And it's not likely, but it could have impact on where you can travel or get immigration status. You understand that? As to the amended count one, I guess, of disturbing the peace. How do you plead? Factual basis.
Mr. taking you back to March the 10th of this year, so a little over a couple weeks ago, were you at or near the location of 1314 West Hillsdale Street in Lansing, Michigan?
Yes, it was.
Is that here in Ingham County?
Yes, it is.
And at that date, time, and location, were you yelling and being overly loud?
Yes, I was.
And you had some interaction with the police where you were also yelling and being overly loud with them, is that correct?
Correct.
To the point that it would have been disturbing to the peace, is that right?
Yes, it is.
Satisfactory, Your Honor?
Any questions from the prosecution?
People are satisfied.
The court is also satisfied with the factual basis. I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. Let's see. Any objection to immediate sentencing?
No, Your Honor, I have spoken with the victim and his guardian in this matter, and we are fine to proceed.
I didn't hear what you said after that. You
I'm
spoke-
sorry, we are fine to proceed with.
Oh, okay. You can make out.
Thank you, Your Honor. Your Honor, Ms. Straub does not deny, I don't think that she has an issue with alcohol, and she has admitted that. I believe she's going to acknowledge that to the court. And she's also going to acknowledge that that's something that she needs to address, and that she is more than willing to do that. I know this situation has been very strenuous and hard on everyone involved, since it involves a young child, since it involves family. Ms. Straub reports to me is that she has not consumed any alcohol whatsoever since this offense date. So I think a term of probation would be appropriate, just to monitor and make sure that she is staying clean and free from alcohol. And I believe that she is certainly going to do that. I think she is certainly motivated to do that, because that's going to not only be beneficial to her, but it's going to be beneficial to those around her, family, her children, and I would ask the court to sentence her accordingly. Thank you.
Does your client want to make a statement about? Okay. Under the circumstances, and this is again a matter that I've had in chambers consultation with the prosecution and the defense about other particularities of distinctive nature of this particular case. And so with that being said, I am going to sentence you per the agreement, which is for you to do a term of probation. I'm going to order 6 months probation. While on probation, you're not to possess or use alcohol, marijuana, or controlled substance. You will be required to submit to random preliminary breath testing and urinalysis testing, okay? And you're not to be at any bars or nightclubs. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. I am going to discontinue the no contact order. Are you employed? You are employed, correct? Okay. And you do need to maintain your employment while on probation, okay? You'll report monthly via Zoom to probation, but you will check in with probation today when you leave. There is a $30 per month oversight fee for each month of probation while on probation. let's see, so if you end up doing 6 months, it'll be $180. However, I will give you information in a moment about your rights to request early discharge from probation. There's a $75 crime victim rights fee that will be assessed plus a $50 state minimum cost. You do have the right to request early discharge from probation once you've completed half the original term ordered by the court, so long as you've not had any violations within the 90 days preceding that request, okay? If you want to make a request for early discharge, you would make the request by using the court's NC 512 form. That's on the court website, or you can get it from your probation officer. You would file a copy of that with the probation department and with the prosecutor's office. The prosecutor's office has 14 days to respond in writing to any request for early discharge from probation. If I set it for hearing, you have the right to hire an attorney to represent you for that hearing. You do not have the right to court appointed counsel for any hearing for early discharge, okay? Okay. Do you have any questions at this time? Any additional matters for the record?
People.
Just one brief one, Your Honor. Ms. Straub was ordered to have a tether as part of her pretrial release conditions. I would just ask if the tether company could be notified that that could be removed.
Absolutely.
Thank you, Your Honor.
You're all set. Thank you. Thank you, Your Honor.
Your Honor, we are going to be requesting for an adjournment for Anderson. We're having, Donnelly still needs to talk to him, but we are going.
Is Donnelly here?
She's over in Flores right now,
She's not over here.
but she'll need to talk to him first.
Well, she's gonna be out for like a week, but she's got a couple other referrals ahead of him, and so I think it's probably gonna take, I would say like 4 weeks to get him evaluated and then get it staffed.
No, I was thinking about my own schedule.
Okay.
I'm out next week.
Okay.
So I was thinking about how I'm gonna coordinate with Jesse.
Gotcha.
If I email her,
We can
if I
email
email
her.
her to by the time I leave,
Yeah.
then hopefully by the time I get back, she's
Yeah.
back and she,
Yeah.
she-
Mhm. Yeah.
I'm just trying to. coordinate that.
Gotcha. Yep.
Because, but I should. So.
Yeah, we need it, even when mental health court, we usually have to wait until the
Yeah,
spring to
make
see
sure
if there's
he's
gonna be eligible.
Cool.
Yeah, I mean, but
Okay.
it is nice to have a preliminary idea of what you guys are gonna offer.
Yeah.
I mean, that would really,
The
but you guys don't wanna do
but
highest charges and R.
I just love
Well, because you already did the work. You're not supposed to do
Yeah.
work until he's eligible, but you did the work, so thank you.
Oh, did she not? Huh? Your Honor, did Alice Kane fail to appear again? Who? Alice Kane. It's not?
Is that on my docket?
Okay, so she's still.
Did some run for the museum.
For,
Yeah, you said you had an officer.
Kane, for
You
Anderson.
said Alex
Yeah.
Kane?
Alice.
Alice Kane?
She bench warranted last at the PCC, so I don't know.
So then
if-
Oh, then she
So it
would
just
have,
wasn't
I
set
would have
on.
taken the
Okay.
exam.
Are you still asking about Anderson?
Yeah, if it, you said you had an officer, I just wanted to make sure which one was.
Yeah, let me-
It would have been.
Except
for.
Yes.
probable
Yes.
cause. Okay. Oh, she was picked up on the warrant. She's, except for probable cause, April 10th.
Thank you. Yeah.
So another thing I'm doing, this is a case that came from home, so.
Okay.
He's made. My concern is we don't know about that.
Yeah.
So we might be sort of-
Yes, yeah.
So.
And,
I talked to him about children and all this, so
what is it?
he has 2,000 full capture in
Okay.
his file in the aggregate. So what?
Any FTAs?
Like, yeah, well, no, I think he actually.
Probably not if he's not.
Yeah, he's no.
I mean,
It's because he.
do you know if he probably stay relatives release?
That's the thing. So that's what
That would be the
I don't
biggest
think
thing.
I'm gonna address it today.
Right, but down the line.
Yeah. Yeah, maybe we can do it, figure it out.
Figure something out. Yeah.
Yeah, 'cause I don't think we do it on other days.
Right, exactly, yeah.
So you know, situation is okay. Do you want me to check with them? Do you need all of them? So I'm gonna need to get this out of my system. I guess I'm gonna put that in. We need to do it up by the boundaries of the waivers. Oh, so that was one. Oh, because they knew that. Okay, that's actually. So for this one, you do adjournment, and then you do by proxy for the request. So you adjourn, yeah, and then you finally want to send proxy for the request. It's on that screen. Oh, great, okay, so we won't touch that. We won't jump into that. So the target is- no, that's the time with this one. That's it. That's just that. Oh, you're handling it. Abby's handling it.
Johnston?
Yeah.
Yeah.
And then, so we just have to. We just have to do this. So we can have to do this one. That was the, so we're good, so all of them are actually. You can see. Are we amending her, or is that the offer? So then we just requested for that. Yeah, the officer truck's very open.
Johnston.
I should be jury zone on that covenant. So I'm gonna go through this. I'm just gonna ask, if they're all here for it, if it's some of them.
Ms. Stephanie, are you ready?
Yes, Your Honor.
This is the matter of the state of Michigan versus Mark Anderson, 25-02492. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant, Mark Anderson, who is standing to my right.
Mr. Anderson is scheduled today for preliminary examination on police officer assault and then an emergency telephone violation. How are we proceeding today?
Your Honor, it's my understanding that the defendant will eventually be accepting a resolution of this matter. We believe that the defendant is a good candidate for mental health court, so we're asking that this matter be adjourned so we can get the defendant screened for mental health court so that we can offer a package deal on all of his open cases.
That is correct, Your Honor. It has been extended and offered for him to be screened for the 55th mental court. And we also agreed that it's best to 4-week adjournment for that.
Okay, we'll reset that. So we can see. PCC April 30th at 10. April 30th at 10 is a new probable cause conference date. Any additional matters for today's record?
Nothing from the people, Your Honor.
Not from defense.
Okay, you're all set for today, sir. Thank you. Does she have an attorney as well as have an attorney?
Yeah.
Now the record in the matter of the state of Michigan versus Gianna Wallace, 26-00492. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Your Honor, David Rudoy appearing on behalf of Miss Wallace, who is present in the courtroom.
Okay, and today was the date that we said we would treat as another probable cause conference for an extortion use of computers claim. Counsel, this matter, are you expecting it to continue to an exam?
Your Honor, I believe the people are intending to amend the charges to a misdemeanor count of false pretenses. Mr. Smith, I don't mean to speak on your behalf, but that was my understanding.
Yes, Your Honor, that is our current position that we are intending to, so I'd like to make an oral motion on the record that we're going to be amending the charge down to false pretenses. And we'll be moving this matter forward under the misdemeanor document.
Okay, so we'll set this for pretrial. To April 7th at 10:30. April 7th at 10:30.
Your Honor, are there any other dates available? I have two conflicts, one of those in Waterford, and the other one in Detroit that morning.
April 21st at 8:30. April 21st at 8:30.
We will make that work. Your Honor, for that pretrial, is that all in person, or are me and my client able to appear via Zoom?
You can appear via Zoom.
Thank you very much, Your Honor.
No problem. Any additional matters for the record?
No, I would just like to, if you can give our office a call, counsel, so we can discuss this matter before the next pretrial. And
yes, I plan on giving you a call to discuss and submitting some paperwork to you as well.
nothing else from the people.
No, sir. We'll get you a notice to appear. Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
Yeah, you can sit down. They'll give you.
I'm sorry? Yeah, they gotta file them and they can play. Let's see, I need to know what's going on with SARS and.
He was that he had an exam in Judge Buchanan. He thought that he was gonna get done around 11. I'll come down there and see where they're at.
Is he planning to run an exam?
We are running the Johnson exam.
On the record in the matter of the state of Michigan versus Richard Johnson, 25-03433, appearance, please.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Good morning, Your Honor. Jacob Sarge, the fourth Assistant Public Defender, here on behalf of Mr. Johnston. He is present at council table. He's standing to my right.
State scheduled for a preliminary examination. Seems that we're ready to proceed.
That's correct, Your Honor.
Any preliminary matters?
Half of the people.
Defense request standard sequestration order, Your Honor.
How many witnesses do you have?
Thank you, Your Honor. We have two witnesses present today. One is the officer in charge who's seated to my left, Detective Watkins. The other is Robert Bloom, who is present here in the courtroom.
Sequestration is ordered. That's what Anderson's fine. You can call your witnesses.
Thank you, Your Honor. The people call Robert Bloom.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes,
You can have a seat.
thank you.
I just feel that sounds like it was over there. Okay, you can proceed.
Thank you, Your Honor. Mr. Bloom, can you state and spell your first and last name?
It's Robert, ROBERT, Bloom, BLOOM.
Thank you. Now, Mr. Bloom, are you familiar with an organization called Bikers Against Predators?
Yes,
How are you familiar with them?
I'm the president of the nonprofit.
Okay. What is it?
We're a 501c3 nonprofit based in Indiana. We travel the United States, catching online child predators.
And you said you're the president?
Yes.
Do you ever participate as like a chatter or a decoy in these operations?
Yes.
What is a chatter in your organization?
A chatter on our organization is someone that responds to individuals that messages them and let them steer the conversations.
And how do you find the people that you chat with?
Typically, we find them by them adding us.
And by adding you, is that social media?
Any social media. Yes.
Okay. On or about June 28th of 2024, did one of your decoy Facebook accounts receive a friend request from a Richard Johnston?
Yes.
What was the persona of this decoy account?
Persona of this decoy account is an underage girl, I believe. But the profile has unicorns as the cover photo and currently a cartoon version of a little girl.
Okay. Did you accept that friend request?
Yes.
At some point, did Richard Johnston start messaging you?
Yes.
At some point, did you switch to a different form of communication? What kind of communication is that?
On our end, it is text now.
Okay. And is that, what is that?
It is a Wi-Fi phone number, basically, to not be, I guess, using our real numbers.
At some point, did you meet with Richard Johnston in person?
Yes.
Your Honor, I've allowed some leeway here in terms of leading questions, Your Honor, but this is very much a leading question.
At some point, did you meet with the defendant? The person is not a leading question. So objections overruled.
Thank you. Where did you meet him?
At his residence.
Where is that?
Here in Lansing.
And was that a meeting that the two of you had planned?
No.
How much time did you spend, or I guess I'll backtrack. Did you actually speak with somebody by the name of Richard Johnston?
Yes.
How much time did you spend with him?
Roughly an hour, maybe.
Okay. Did you get a good look at him during this hour?
Yes.
Do you see Richard Johnston here in the courtroom?
Yes.
Can you point him out and describe something he's wearing?
He's wearing a blue jumpsuit to my left.
Your left. So that would be my right.
Yeah.
Okay. Thank you. Your Honor, at this time, I request the record reflect the witness has identified the defendant.
Any objection?
Yes, Your Honor, like a foundation. Thank you.
Objections overruled.
Thank you, Your
So
Honor.
noted.
Now going back to your communications with the defendant, what kind of device were you using?
We were using a burner phone.
Is that like a flip phone, smartphone, something else?
Usually they're cheap Samsung phones, so smartphone.
Okay. And the phone that you used in this instance, did it have the ability to connect to the internet?
Yes.
And is that how you use text now?
Yes.
Did you turn over the phone that you used in this case to the Lansing police?
If requested, yes, I do not remember if we did.
Okay, would reviewing a statement to the police help refresh your memory?
Possibly, yes.
Okay, let me just find it. Your Honor, if I may approach the witness. Now, Mr. Bloom, I've handed you the police report in this instance, page 3, under the evidence portion. If you can read that silently to yourself, and then if that refreshes your memory, you can turn it over and let me know.
Your Honor, I'm just going to object because these responses potentially going to call for hearsay in response in terms of whatever these messages were.
This is to remind him of whether or not he turned over the phone.
That's correct.
Correct?
That's correct.
Objections overruled.
Thank you, Your Honor. Did that refresh your memory?
Yes.
Okay, I'm just going to retrieve that from you real quick. Okay, and do you remember if you turned over your phone to Lansing Police?
Yes, I did.
You did, okay. Did you give them permission to search the phone?
Yes.
Okay. I'm showing Defense Counsel People's Proposed Exhibit 1.
And I'm going to state my objections now on grounds of lack of foundation as relates to the phone. The foundation has not been established that will connect the alleged device or the communications to Mr. Johnson. Thank you.
Your objection is as to foundation, you said?
Yes.
Does she want to respond?
Can I lay the foundation?
Yes.
Okay. May I approach the witness, Your Honor?
Thank you.
Now, Mr. Bloom, I've handed you People's Proposed Exhibit 1. Does that look familiar to you? You can leaf through it if you need to.
Yeah, it does.
Okay. How does it look familiar to you?
Well, I've seen it. Yeah, these are the communications.
The communications you had with Mr. Johnston?
Correct.
Okay. Do they fairly and accurately depict the communication that you had with Mr. Johnston?
Yes.
Okay. Your Honor, at this time, I'd move to admit People's Proposed Exhibit 1. Additionally, I believe that this would be admissible under 766.11B, as it is a report compiled by law enforcement that is a forensic report and does not need further foundation under the preliminary exam section.
I would object to this, Your Honor, because Mr. Bloom is not law enforcement. This person is not a law enforcement officer. This portion was not conducted by a law enforcement agency.
The report was not compiled by law enforcement, you're saying?
No, the messages were compiled by a private citizen who operates a nonprofit.
The messages were elicited by a private citizen, but the report was compiled by law enforcement.
That's correct. It was a celebrate extraction report.
Objections overruled.
And further, Your Honor, the messages contain hearsay, so I also object to the messages being included on those grounds.
Any messages that we're admitting for substantive purposes are party opponent statements from the defendant. Any messages from Mr. Bloom are for the effect that they have on the defendant as a listener.
Objections overruled.
Thank you, Your Honor.
Thank you.
Now, Mr. Bloom, I'd like to turn your attention to page 3 of that report.
Yes.
Does the defendant indicate where he's from?
Yes.
Where is that?
That's on page 2.
Okay.
He says he's from Lansing.
And do you say where you're from?
Yes,
And where did you say you were from?
we are from Lansing as well.
Now, turning to page 4, do you discuss your age?
Yes.
How old do you say you are?
11.
Does the defendant discuss his age?
Yes.
How old does he say he is?
12.
Did you believe he was 12?
No.
Why not?
Due to the pictures of them in the profile.
Now, going to page 10, and I'll give you a second to flip to it. Did the defendant send you a photo of himself?
Yes.
And I know that it's not depicted in the report, but do you recall what that photo was?
No.
And do you recall if that photo was consistent with the other photos you had seen of him?
Yes.
Did he look like a 12-year-old?
No.
Now, looking at page 22. Does the defendant ask you about losing your virginity?
Yes.
And then looking at page 23. Does that conversation about sex continue?
Yes.
Did he say anything specific that he was going to do?
I will make you swear.
What was the last date that you made contact with the defendant?
So the day that we had contact with authorities.
And was that July 17th of 2024?
Yes.
And was the initial contact when he messaged you back on that June date?
27. Yes.
Oh. Now, you went and met with him in person, right?
Correct.
Did you have a conversation with him about these text messages?
Correct.
Did he indicate if he was in fact the person that you were communicating with?
Yes.
And was he the person?
Yes.
Did he say anything else about this conversation?
Not to my remembrance, I guess.
Okay, that's all right. I have nothing further.
Cross-examination.
Thank you, Your Honor. Mr. Bloom.
Yes.
You run a nonprofit organization, correct?
Yes.
And you're based out of Indiana?
Yes.
And where is your principal place of organization? Where is it based out of, specifically in Indiana?
Goshen, Indiana.
And all your computers, all your devices, all your technology is based out of that location, correct?
Yes.
Okay. So when you were sending these messages, or someone from your organization, whoever sets up these decoys, it's all entirely based out of Indiana, correct?
Not always.
Okay. But your company or your nonprofit is based out in, correct?
Correct.
That's where it's legally organized, and that's where you have paperwork on file in the state of Indiana, correct?
Correct.
You don't have any offices in the state of Michigan, correct?
Correct.
Okay. So when you're exchanging those messages at the time, whoever was sending those messages, they were based in Indiana, correct?
Based, yes.
Based in Indiana, all right. And you had an exchange about stating something about Lansing, correct?
Correct.
Was that in Ingham County or in Eaton County?
That I don't.
Okay. And do you remember what date you had that exchange in Lansing? About Lansing?
Reviewing messages now.
Okay. And how specifically did you find Mr. Johnston's address?
Just through online public record.
Through online public records. Okay. So you never had a way to trace specifically from Mr. Johnston allegedly, or whoever was sending these messages. You had no way of knowing where the messages were actually coming from, correct?
Correct.
Okay. So you were based entirely in Indiana and you were getting messages, but you don't know where the messages were coming from.
Correct.
And in terms of your affiliation with law enforcement as a nonprofit organization, is your nonprofit regulated by the state of Indiana to conduct law enforcement operations?
No.
Okay. So the extent of your affiliation with law enforcement then is just essentially as a private citizen, correct?
Correct.
Okay. And do you have any specialized training to conduct these types of operations on your own?
5 years worth of operations, yes.
Operations that were just conducted on your own in terms of your own private organization, correct?
Correct.
Okay. So you have no law enforcement endorsed or specialized training that say police officers or other types of law enforcement agencies that would receive, correct?
No, not required.
Okay, thank you. No further questions. Thank you.
No, Your Honor, thank you.
Thank you. You may be excused, sir.
May I publish people's one
Yes,
before I
thank you.
forget?
You can call the next witness.
Thank you, Your Honor. People call Detective Andrew Walkies.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
You can have a seat. You can state your first and last name and spell both.
Andrew Watkins, ANDREW, last of WATKEY.
Thank you, Your Honor. Detective Walkies, where do you work?
Lansing Police Department for the city of Lansing.
What is your job title?
My current job title is the Detective of Special Victims Unit and Internet Crimes Against Children Task Force.
What are your general responsibilities?
Special Victims Unit handles crimes involving vulnerable children or vulnerable adults, CPS referrals, specifically due to the fact that I specialize in internet crimes against children. I handle additional responsibilities of cases that involve accosting children for moral purposes, child sexual use of activity, and materials involving phones, computers.
And was this the position you were in back in September of 2024? It was not. What position were you in September of 2024?
September of 2024, I believe I was working with the Lansing Police Department in the Special Operations Section as a regulatory officer, aiding the Special Operations Section with child predator operations.
Okay. Would you say that's kind of tangentially related to what you do now?
Yes.
Okay. Now, in September of 2024, were you assigned to an investigation concerning a Richard Johnston?
Yes.
How did you become assigned to that investigation?
I was advised by Sergeant Kevin Schlegel that I would be taking over the investigation.
During your investigation, did you obtain a search warrant for Robert Johnston's phone or Richard Johnston's phone?
Yes.
Was it in police custody at that time?
It was.
How did you know it was Richard Johnston's phone?
Based off the initial police report made by Roll Patrol and the evidence tabulation.
What kind of phone was it?
It was an Android smartphone, but it was off-brand. It can't give you the perfect model, make it model.
Okay, but you said smartphone?
Yes.
Based on your training and experience, does that phone have access to the internet?
It does.
As part of your extraction, or I guess let me back up. Did you conduct an extraction of the phone pursuant to a search warrant?
I requested an extraction done by MSPCC. Yes.
Okay, did you receive a report for that?
Yes.
As part of that report was location information for the device provided?
Yes.
Does that include during the times the defendant was messaging the chatter during this incident?
Yes.
What kind of location data did you get?
Latitude and longitude location data.
Were you able to determine what that latitude and longitude was?
Yes.
Where was that?
I believe, I don't remember the numbers, but it was on Seaway Drive in Lansing.
And is that within Ingham County?
Yes.
State of Michigan?
So let me correct that. It may technically be in Eaton County, but with the mile border, Lansing Police Department, Ingham County does handle those cases.
Okay, so it's within a mile of the border?
Yes.
All right. Now, at some point, did you re-review the extraction contents from your initial search warrant?
Yes.
What prompted that?
I was requested by the Ingham County Prosecutor's Office to turn over the extraction contents of the phone, but due to the fact that in 2024, I was just starting my process in crimes against children and extractions of cell phones to now, I have been through multiple more trainings, received certifications for electronic and mobile communications when it comes to the extraction of those cell phones and the forensic examination of the data. That being said, due to the topic of the case being accosting a child for immoral purposes and the statements made by Johnston to Roll Patrol officers, I re-reviewed the phone to ensure that there was no child sexually abusive material on the phone in order to stay within the realms of the law and not disseminate to another person material that might be on the phone.
Okay, and when we say that you re-reviewed the extraction, were you pulling data directly from the phone again?
No.
And how, can you explain a little bit how that works?
Yes, the Lansing Police Department houses an electronic data server where cell phone extractions, the data extractions will be housed after the extraction is completed. Although MSP did do the extraction, MSP Cybercrime Unit did do the extraction, the raw data or the initial extraction is delivered from MSP to LPD in order to house that evidence for the purposes of any needs of it in the future.
So it was that data that you were just going back through again?
Yes.
All right. Did you find anything of any value to you, your investigation, when you looked at it again?
I did.
What did you find?
I found what I determined to be child sexually abusive material, later prompted me to not turn the contents of the phone over to the county prosecutor's office.
And what made you believe that it was child sexually abusive material?
From the images that I viewed, one most importantly, the size disparity between the male genitalia and the female genitalia in the picture depicted that it was a smaller child, toddler, possibly, and an adult.
Okay. Can you describe what was happening in this photo?
Yes, the white female child, who I believe to be a toddler based on the size discrepancy, was on her back with her legs spread. Her underwear was pulled off to the side, and then there was a male genitalia penis that was erect, pointing towards her vagina with a white substance on her vagina.
And based on your training and experience and knowledge, are toddlers someone who is typically finished with puberty?
No.
Were you able to determine where on the device this image was stored?
Yes.
Where was it?
It was stored in the gallery section of the phone.
Okay. And this is the same phone as the chat logs that were used?
Yeah.
I have nothing further.
Thank you. Just briefly. So when you pulled the longitude and latitude information, did you bother to cross-reference to see just how far it was from the border with Eaton County?
Seaway is within a mile of the border of Lansing and England County.
Okay.
So yes.
And how did you cross-reference that?
Utilizing latitude and longitude and entering it into Google Maps on the internet.
Okay.
There's also a map display inside of Celebrate that also sometimes shows that map, but I cannot tell you 100% that for this specific content.
Okay, so how far away is this location then? The Seaway Drive address from the border of England County?
I don't have an exact inventory, sir.
Okay. And did you bother to run the longitude and latitude information for each of these individual alleged images and anything else you claim that you pulled off this device?
Yes.
Okay. And were they at different locations? Were they always at the same location?
I believe there was over 2,000 latitude and longitudes on the device, so I did not run every single one, but the ones that were within the date and time range of what this incident occurs to are the ones that I ran.
Okay. So there were over 2,000 data points potentially that were extracted when you did this extraction, correct?
Yes, as the phone is being used for more than a few days when I chat through.
Okay. And so the phone was moving around, it's safe to say, from different locations, correct?
Yeah.
Okay. And the phone doesn't, you're not able to tell the individual user logging into the phone when you pull these extractions, correct?
Did you rephrase that question?
Sure, there's no verification data of a user ID being entered into the phone when you pull these extractions, correct?
What exactly do you mean by a user ID?
Sure. You have a password on a phone, correct?
Yes.
A unique password that's unique to a particular individual.
Yeah.
Okay. There's no data that verifies that a particular password that is directly connected to Mr. Johnston was used at the time that these data points were entered.
Passwords don't directly connect a cell phone to a person. Passwords connect a cell phone to a user account that is logged into the phone.
Okay. So you can speculate that Mr. Johnston's the user, but you don't know for certain that Mr. Johnston is actually the user on the dates and times of these alleged messages, correct?
Yeah.
Okay. And in terms of the messages themselves, that you had a chance to review and everything else, did you ever get an address directly from a person claiming to be Mr. Johnston?
No,
Okay. And approximately how long of a search did you run on Mr. Johnston's phone?
forensic data examinations, depending on the size of the phone, could take anywhere from an hour to an undetermined amount of time. So I cannot give you an exact amount of time, but I did a forensic data exam on that phone.
Okay. And how long of a time frame did you run an examination of?
Time frame, so you're talking the
Like the months?
dates on the phone?
Yeah, like how much data did you comb through and kind of what was the starting point?
I would have to review my search warrant to determine exactly what I asked for on the phone, but I stayed within the bounds of my search warrant.
Okay. And in terms of the total amount of data, do you have any idea how much data was ultimately extracted from the phone, or just in terms of size, in terms of the extraction?
I don't have a memory of the exact size, but a full file system extraction was conducted by MSP, and I believe it was reported in the report.
Okay. And you testified to this earlier, but just so we're clear, so what is your training in cell-brite extractions again, or what's your specialized training as it relates to these types of searches?
I have certifications in Cellbrite. I'm currently working on my CCNE, which is a certified Cellbrite mobile examiner. I have CCO, CCPA, and CASA certification.
Okay. And how long have you been in your current employment?
Almost 10 years.
Almost 10 years. And have you worked in this particular area for the full 10 years?
No.
Okay. Now, when did you start working in this particular area?
Became a detective approximately 2 years ago, and I was working with special operations veterans doing phone examinations for 2 years prior to that. So,
okay, thank you. No further questions, Drew. Thank you.
Can you read the record of your witness?
None, Your Honor, thank you.
Thank you. Detective, you may be excused.
Thank you.
Any additional witnesses for the people?
No, Your Honor, people rest.
Defense calling witnesses today?
No witnesses today, Your Honor. Thank you.
Thank you, Your Honor. I'm gonna go through the counts a little out of order because that's what makes sense in my brain. So I just asked the court to hang on with me for a second. So we have your testimony that this incident occurred between the dates of, I believe it was June 27th, 2024 to July 17th of 2024. That this incident occurred with the person identified in the courtroom as Richard Johnston by Mr. Bloom as the person on the other end of the chats. Additionally, we have testimony from Detective Watkins that during his extraction of the phone, he was able to determine that during the times of these messages, the phone was at the location at Seaway Drive within Lansing, which is within a mile of the border of Ingham County, which under the venue rule puts this court within proper jurisdiction. So I believe the elements of date, ID, and venue have been met. Now moving on to the elements of the offense, we have, starting with count 2, accosting for immoral purposes. We have somebody that the defendant believes to be.
I have that as count 1.
Oh, is it count 1? Mm-hmm. Oh, okay. Then with count 1, I'm not going out of order then. We have somebody that he believes to be an 11-year-old girl, that he is messaging, that he's pretending to be a 12-year-old boy, talking about taking her virginity, making her squirt, proceeding with sexually explicit activity that he wants to engage her with. I believe that that is sufficient for probable cause as to accosting her for an immoral purpose, as he is trying to entice her into doing these acts. As to count 2, at the using a computer to commit a crime, he was using a cell phone that had internet access in order to message this person, and so he did use the computer to do the accosting. Additionally, the people are requesting an added count of aggravated possession of aggravated child sexually abusive material. The detective testified that he reviewed the data extraction from the phone and did find an image that he understood to be a child, toddler age, that isn't somebody that's gone through puberty, making them a prepubescent minor engaging in a sex act with an adult male. That is clearly a sexual image that was used for sexual purposes. It was in the possession of the defendant on his phone that he was using to communicate, to entice a minor or somebody he believed to be a minor to do certain acts. Additionally, he did possess the phone that had the internet access. It used the phone to house the image on the phone. So I believe that there is an additional count of using a computer to commit a crime punishable by 10 to 20 years for probable cause as well. And I'd ask add account for that as well.
Mr. Sir.
Thank you, Your Honor. Respectfully, the defense would object to the request for bind over here. One particular issue is jurisdiction. Respectfully, the people have not met their burden as relates to establishing a jurisdiction and venue as it relates to charges here. The person who induced this chain of alleged messages could not tell the court where the messages were originating out of. The person who induced this alleged chain of messages, specifically as it relates to counts 1 and 2, is based out of Indiana. This person is a private citizen. They have no direct affiliations or connections to law enforcement. They apparently run this operation out of Indiana, where they have a organized and apparently registered nonprofit organization. So all of their devices, all of their electronic devices, computers and otherwise, are based out of that jurisdiction, based out of that location. Obviously, you don't have a young girl on the other end of these messages. You have a grown man who is pretending to be a young girl, who is soliciting these messages. Well, clearly, there was never an alleged minor involved in any of this in terms of counts 1 and counts 2. I think there are serious.
Does the jury instruction require there to be one, or does the jury instruction require for the person only to believe that they're talking to a minor?
Your Honor, it reads, individual he or she believed was a child less than 16 for child accosting for the moral purpose.
So why is your argument that the person was not that relevant and here today? Why are we wasting the court's time?
We're not wasting
with
the
that
court's time,
argument.
Your Honor. It goes to, for one thing, it goes to the credibility and the relevance of the messages. And second, it also goes towards doubts about intent, and it also goes to doubts about some of the, also it goes to doubts about the user on the other end too.
It goes to doubts about the user?
Yes.
What do you mean?
Yes, Your Honor.
I don't know what you mean.
Sure. The people have the burden to show that it was Mr. Johnston who was sending these messages. And respectfully, the proofs have not definitively established that it was this Mr. Johnston who was the person allegedly sending these messages.
But whoever was initiating these messages from Indiana, Robert Bloom or whoever, how does that have any correlation to whether or not this was actually Mr. Johnston who was responding to them?
It's the prosecutor's burden to show as Mr. Johnston who was.
We understand. That wasn't my question, whose burden was it? We already know whose burden it is. But my concern and question is about your argument, which was that because Mr. Bloom is not a child, but only pretending to be one, that somehow goes against bind over when the elements of the charge specifically state that it doesn't have to be a child. It only had to be that Mr. Johnston believed it was a child.
Well, it raises doubt about the credibility of the claims about, for one thing, it raises doubts about the credibility of the investigation. It raises concerns about the portrayal on the other end that the person was presenting themselves as a person under the age of 16.
Okay.
So it goes to credibility, it goes to weight in terms of the evidence that's been presented so far. And also in terms of the added request, the request for the added count, Your Honor, respectfully, again, I think there's too much doubt here about who the user was at the time, where the alleged devices were being operated at the time. Allegedly, it was a phone that was being used, and there were over 2,000 different GPS locations, according to the detective. So that raises doubt about venue, that raises doubt about jurisdiction, and respectfully, we don't know. Officer claims that was within a mile of Eaton County, but with 2,000 potential different data points and without testimony that corroborates that the specific data points that this particular detective was referring to clearly connect the allegations against Mr. Johnson. I don't respectfully, the people have not met their burden as it relates to jurisdiction and venue too. So just to summarize, the defense requests that these counts be dismissed, Your Honor, because there are too many doubts at this point about venue and jurisdiction, and also who the alleged user was involved on the other end of these alleged transactions. Thank you.
Thank you.
Thank you, Your
further
Honor. Just
argument?
a few things. Mr. Bloom did meet with Mr. Johnston in person, and he testified here today that Mr. Johnston was the person that he met with, and that Mr. Johnston admitted to being the person on the other end of the discussion. So I don't really think there's an issue there. Additionally, Detective Watkins did testify that he was looking specifically at the location data points in relation to the messages in these files that indicated that he was within the proximity of that Seaway Drive address that is within that border of Ingham County. So we're talking about doubts here. This is a probable cause standard. The people have more than met their burden at this point. I asked this court to bind over on the charges of complaint, and the 2 requested. Oh, sorry, thank you.
Okay, you said the 2 requested. I got that you requested 1 count. You requested 2 counts?
Yes, aggravated possession of aggravated CSAM, and then using the commuter to commit a crime 10 years or more that's related to the aggravated CSAM.
Oh, okay. Got it. Okay, today was a date scheduled for a preliminary examination. The burden is squarely on the prosecution. They have to establish, Mr. Johnson, that there is sufficient probable cause that a felony was committed, or that the felonies you're being charged with were committed, and there's sufficient probable cause to charge you as the individual who committed the felonies. This is not a trial. They don't have to prove anything beyond a reasonable doubt. They just need more than mere suspicion that the allegations took place. The court's the sole determiner of any credibility at this point. I'll also weigh the evidence as presented and make a determination as to the people's likelihood of success at trial. We heard testimony today first from a Robert Ballou, who said he's from an organization, a 512c nonprofit called Bikers Against Predators, whose purpose, I believe, is to try to catch online predators. He testified that he has, or the organization has, decoy or chatter accounts that they use on social media to try to attract and or locate predators or potential predators. I gave testimony about a series of messages or communications that took place between the dates, the time of June 22nd to July 17th, 2024, in which he's described the social media account to have a profile picture of a unicorn, I believe, and then some a cartoon generated child of sorts, and that they received a friend request from the person he later identified as a Richard Johnson. He testified about some communications that took place. Those communications progressed to communications that were sexual in nature, and that he represented, he being Mr. Bloom, that is, represented or purported to be a female child at about the age of, I believe, 11 or 12, and that the defendant purported to be a male at around the age, I believe, 11 or 12. And so based on that information, it was turned over to law enforcement. We had testimony then from Detective Watkins, who performed a search warrant as part of the investigation. There was a data extraction from the cell phone, which was already in the custody. A cell phone number having been identified as being owned by Mr. Richard Johnston. And again, it should be mentioned that Mr. Bloom testified with meeting with Mr. Johnson and having had a conversation with him for at least an hour, and yet having identified him in the court. Based on the extraction in the investigation, Detective Watkins was able to retrieve latitude and longitude coordinates, which placed the location of the transactions for communication at or near the area of Seaway Drive in Lansing, Michigan, which we believe to be Eaton County, within the 1 mile radius of this court, which makes venue appropriate. Mr. Sarts has argued that there's issues with venue, which the court disagrees, based on the testimony and the information just stated on the record. So venue is appropriate in this court, regardless of where the transaction was initiated, just because the action or the communications from Mr. Bloom would have taken place allegedly from Indiana. And just because there were multiple different coordinates that may have been pulled from the defendant's phone does not cast doubt about whether or not there was accurate latitude or longitude data that put this communication from Mr. Johnson's phone from the area at or near Seaway. There's nothing that would discredit that. So that the court is satisfied with venue. Now, as it relates to the elements of accosting the child for immoral purposes at the time of trial, the people who need to prove beyond a reasonable doubt first that the defendant accosted, enticed, or solicited or encouraged the complainant in this matter, which is Mr. Bloom, but the defendant allegedly believing it was a young girl. First, that or second, that the defendant, that the complainant was less than 16 years old. It does not matter whether the defendant knew the complainant's age. Second, that the defendant believed that the complainant was less than 16 years of age. It does not matter if the complainant was in fact older, as long as the prosecutor proves that the defendant believed that the complainant was less than 16 years old. And that either the third, that the defendant accosted, enticed, or solicited the complainant, he intended to induce or force that complainant to commit an immoral act, or submit to an act of sexual intercourse, or submit to an act of gross indecency, or submit to an act of depravity, submit to an act of delinquency. It does not matter whether they actually submitted to such act. Or third, that the defendant encouraged the complainant to engage in an immoral act, engage in a sexual intercourse, engage in act of gross decency, indecency, engage in act of depravity, or engage in act of delinquency. And again, it does not matter whether the complainant actually engaged in such act. And that's essentially what we have here. We have a situation where Mr. Bloom pretended to be a young girl, and that caused the person on the other end who based on Mr. Bloom Mr. Johnson admitted to him that it was him on the other end. There's no question there. That it was Mr. Johnson if we believe Mr. Bloom, and I have no reason to discount Mr. Bloom's testimony. And so that Mr. Johnson believed that he was talking to someone under the age of 16. Mr. Johnson allegedly pretended to himself be someone under the age of 16. And he either allegedly accosted, enticed, or solicited or encouraged the person or the young lady that he believed to be under the age 16 to engage in a immoral purpose. For that reason, the court is satisfied that there's sufficient probable cause as to count one that will be bound over, as well as count two, computers used to commit the crime in count one. The people are requesting bind or addition of a count three, which would be sexual abusive material.
Aggravated,
based on images that were found in the defendant's phone during the extraction. The court, based on the testimony of the detective, will grant the request to add that count, as well as a accompanying count 4 of computers used to commit a crime, to accompany that. Those counts will all be bound over to the circuit court. Again, this is bound over as a habitual offender, third offense notice. The bind over date is April 8th. That's the date the circuit court's receiving the file from the district court, not a date that you need to appear in court. Okay, Mr. Johnston, your next court date will be a pretrial. Your attorney will be made aware of that date. Do you have any questions at this time? Let's see. And count three aggravated. A bond was set at 100,000 cash surety. That will continue with GPS. Are there any additional matters for the record?
Not for the people.
Your Honor, I would respectfully request that you preliminary examination transcripts and may it be heard on bond. Thank you. Respectfully, I request reduction in Mr. Johnston's $100,000 cash security amount. He's not a flight risk. He has plenty of good, solid connections to the community. He understands the severity of the charges here. If he gets released, he'll make sure that he complies with all the court's orders. They'll show up his court dates. He has opportunities to potentially work. He has a lot of physical issues right now, Your Honor. I'm not concerned about the level of care that he's receiving in Ingham County Jail. He'd like the opportunity to be able to be released and pursue his own medical care. He's been also concerned about his treatment by some of the other inmates in the facility as well, Your Honor. That's another concern, his safety and his well-being. And his mother's been very supportive of him. She's here. He has that additional family support in the area who can keep track of the location. And respectfully, because he's indigent, there's no way his family has the means to be able to post a $100,000 cash security bond. He's been in custody now continuously for an extended period of time. And at this point, respectfully, I request a reduction in his cash security. Thank you.
Thank you.
Thank you, Your Honor. This is the third request for a bond reduction. The first two were denied. In fact, at the last court date, this court indicated that based on the information in the court's possession at the time, the court believed that the bond was actually set too low. The only thing that's changed since then is 2 additional counts have been added, both 10-year felonies. Mr. Johnston has a history of sexual abuse to children. He admitted to the offenses here. He was in possession of child sexually abusive material. He's a danger to the children in this community. He is exactly where he needs to be right now. I request bond remain the same. Thank you.
I definitely remember at least one of the other requests to amend the bond, and I did indicate that I believe that the bond was set appropriately or too low. I think originally the people requested 150,000 cash surety. And again, the court at the time of the arraignment for Mr. Johnston, he was then at that time only facing 2 felonies. He's now facing 4 felonies because we had to set out the exam because of this suspected CSAM information on the phone or the Google Drive. So whereas they're investigating one crime, they find evidence of potential crimes against other children. And so we have a situation where he's now facing 4 felonies alleging to have committed sexual crimes against children. And this is after having had 2 prior criminal sexual conduct convictions, at least one including a minor child, both having been reduced from sexual penetration. If the allegations in this case before the court are true, and based on testimony, the defendant has already admitted to them, then I can think of greater places that I believe that the defendant should be, that's not even jail. And it's definitely not at home. He's a threat to public safety and to children, if true. And I don't care if his mama and grandmama is here. That has not prevented him from having convictions for criminal sexual conduct. And it has not prevented him from having new charges for criminal sexual behavior against children. And so with that being said, the bond will be increased to 150,000 cash surety, which was the original request of the prosecution. Any additional matters for the record?
No, Your Honor, thank you.
You can get your exhibits.
Oh, thank you.
Nothing further, Your Honor. Thank you.
Thank you.